Hello, I'm Amanda Moore. I'm the Director of the Clearinghouse Community. Welcome to the Advocacy Exchange for December 2016. The Advocacy Exchange is our monthly conversation with advocates advancing change. And both the Clearinghouse Community and the Advocacy Exchange are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. Today, I am joined by the self-styled Federal Access Group. I'm glad to have them here with me. They've now written 24 annual recaps of Supreme Court terms and what the court said about access to the federal courts for our clients. They were our Advocacy Exchange guests last December, and I'm happy to welcome them back this year, so I'll introduce them to you in turn. We'll start with Gary Smith. Gary's the Executive Director of Legal Services of Northern California, and he's joining us today from Sacramento. Hi, Gary.
Hello.
Also joining us from Sacramento is Mona Tawatao. Mona is a senior litigator at the Western Center on Law and Poverty. Hi, Mona.
Hi, everybody.
We also have with us Jane Perkins. Jane is the Legal Director at the National Health Law Program, and she's joining us from Chapel Hill, North Carolina. Morning, Jane, or afternoon there, right? Hi, Jane.
Good afternoon, or morning as the case may be.
Yes, we're spreading many time zones today. And we also have with us Gill Deford. Gill's the Director of Litigation at the Center for Medicare Advocacy. He's joining us today from Connecticut. We don't have Gill's video feed, which I'm sure he's very disappointed about, but we can hear him. So, hi, Gill.
Hi, good morning, good afternoon. I'm very sorry you can't see me because I actually put a tie on.
Oh, wasted effort. Right. Well, this group's most recent Supreme Court recap is our latest Clearinghouse article. You can find that at povertylaw.org/clearinghouse. We will only be able to touch on a fraction of the content in that article today. It's a hefty article and goes into detail on a lot of cases. Plus, you get the citations and things there. So I encourage you to check it out. That's at povertylaw.org/clearinghouse. So before we get started talking about cases, let me tell you how you can be part of this conversation. We really want to hear from you. If you are watching this live stream through YouTube Live, and you're watching on a laptop or a desktop computer, you'll notice to the right you have a chat box there. You can send us questions. I'm watching that while we're talking. Go ahead if you want to give it a try and just send us your name and where you're watching. We would love to hear from you. I think if you're watching on a mobile device, I think the chat box is at the bottom of the screen. Another way you can send your question to us is the old faithful email. You can send an email to me. I'm monitoring that while we talk. My email address is Amanda Moore, M-O-O-R-E, at povertylaw.org. And I'll remind you of that periodically throughout the broadcast. But we would love to hear from you. So go ahead and get those lines of communication open. Everyone who registered for today's event will receive a follow-up email within the next few days. That email will contain a link to this recording and also a link to the article. And I see Gill and his tie.
Yeah.
Nice tie, Gill.
Thanks. It's lavender.
Yeah.
Liking it, Gil. Very nice. Very nice.
I'm glad we get to see you. And we have some people letting us hear from them. We've got Jean in Connecticut and Genevieve in Los Angeles tuning in. So thanks. Thank you very much. All right, well, let's get started talking about the Supreme Court. So last year when we did this, we were able to talk about cases and their implications. This year, however, we are living in, shall we say, more interesting times. And I think that what's probably on a lot of people's minds is what's going to happen to the Supreme Court in a Trump administration. So let's go ahead and talk about that, and then we can get into some of the specifics of the cases. So since last year, we've seen Justice Scalia's unexpected death, and then we saw the Supreme Court completely refuse to consider President Obama's nomination to replace Justice Scalia. So we had this 8-member court for much of the last term. Gill, I'll start with you. Where do we go from here?
Well, where do we go from here? I think the main thing that I take out of the last month is that advocates in our situation are going to be switching to a a much more defensive mode than we were expecting. I think it's likely that the Senate will confirm Trump's nominee, whoever that may be, pretty quickly, and I think we'll have a ninth member of the Supreme Court probably before the end of the term. So that particular problem will go away. In a sense, I don't think it'll mean major changes to the court at this time, because whoever replaces Scalia can't be any worse than Scalia from our perspective. And so that means that, as in the past, Justice Kennedy will probably be the swing vote, which means he'll come down the right way in some cases and the wrong way in some cases. So I guess our major job at this point is just to do the best we can to protect as much as we can for our clients. That's how I see it.
Well, thanks, Gill. We've had a whole bunch of people join us, and unfortunately I can't run through the roster, but hello and welcome to all of you. Thanks for tuning in. So let's move and talk about some of the cases that came out of the 2015 Supreme Court term. And of course, by that we mean the term that began in October 2015 and ended this past June. Your article discusses a number of cases. Let's talk about some that came out that, while we're looking ahead to what we may be facing in a new administration, were there any cases decided last term that might be useful for advocates if they're facing, kind of unpredictable or difficult federal administrative agencies? Gill, I'll stick with you for that. Is there anything we can look to from last term?
Well, I think probably the one that might be most useful is the one called Encino Motor Cars, and I'm looking for my notes on that. Of course, I can't find them. I wasn't expecting.
I totally on the spot.
You want to do that, Gary?
Let me jump in here.
Okay.
With the Encino Motor Cars is a case that is very similar to a case that was decided in 2012 by the court called Christopher versus Smith, Kline, and Beecham. And and I think that the majority in both of these cases were doing something that they certainly didn't anticipate would be end up being a helpful doctrine for us. But what happened in the 2012 case was that the Obama administration's Department of Labor, gradually a more pro-employee Department of Labor, issued a regulation that removed the exemption from wage and hour overtime protections for pharmaceutical salesmen of different kinds. And it was an abrupt departure from many years of Department of Labor policy that had ruled that those pharmaceutical salesmen, when they worked overtime, were not entitled to overtime pay. The Supreme Court, the conservative majority, declined to grant any deference to that regulation because it was such an abrupt departure from long-standing policy that went the other way. So the salesman lost in that case, and then the court went on to interpret the statute itself without deferring to the regulation, and decided that pharmaceutical salesmen did not fit into the category of employees who could get overtime pay. So this term, in the exact same structural thing happened, except it was a group of auto dealership service advisors. They're the guys that when you drive your car in for service, they're sort of salesmen for the service department of your auto dealers. So a group of them in California also sued and said that they were not getting, they had long been held by Department of Labor and other rules to be, again, exempt from overtime. They said, well, we shouldn't be exempt, and they filed a lawsuit. And they were aided by a very recent Obama administration Department of Labor regulation that also had reversed long-standing, decades-long policy that had exempted these guys, these service advisors, from wage and hour protection. The Supreme Court did exactly the same thing that they had done in the Christopher case, to a point, which is that they declined to defer under the Chevron deference rule to the agency regulation because it did not adequately explain why it was changing its position. And pretty clearly it was changing its position because it was a new administration and they had different issues, and they were moving in a different direction with respect to the sort of overall employee protections under the Fair Labor Standards Act. So they declined to defer with, very strong language about how, you can't just change abruptly long-standing agency and administrative policies and rules. You have to have a very reasoned, adequate explanation. So they get no deference, and those principles are embedded in the Supreme Court's deference doctrines, and so they refuse to defer to the regulation. In this case, interestingly in a small way, they did not go ahead and simply interpret the statute on their own and tell the service advisors they were out of luck for their overtime pay. They sent it back to the Ninth Circuit to do that. And one of the justices filed, a couple of them complained about that. They said, why don't we just go ahead and interpret this? Meaning, why don't we just go ahead and shut the door on these guys like we did in that case 3 years ago with a pharmaceutical salesman? I think probably the reason they didn't do that was they didn't have the votes for it because Scalia was gone. But what this case means is that if a new administration and all these new administrative agencies start doing, as we expect they will, wacko stuff, changing rules, changing administrative policy, these two cases will get in their way. And the language in these cases would be just as equally applicable to abrupt policy-oriented or political-oriented changes by new administrative agency heads as they got in the way of Obama's Department of Labor.
Thanks, Gary.
Yeah, thank you, Gary. Thank you for jumping in. Great job. I mean it.
Well, while we're talking about administrative agencies, there were quite a few cases this past term that dealt with administrative law topics. So let's stick with those for a second. Mona, I'll turn to you. U.S. Army Corps of Engineers v. Hawks Company was another admin case. It discussed the Administrative Procedure Act and final agency action. So can you tell us about that?
Yes, and I'm going to, hi everyone, I'm going to start with my elevator speech because for some reason Google Hangouts is kicking me off. And so I think the takeaway from this case is if you want to understand what the criteria for when a federal agency's action is final, then you want to read this case. Final for purposes of the aggrieved party being able to go to federal court and challenge the agency's action under the APA, or Administrative Procedure Act. In this case, Chief Justice Roberts, writing for the majority, the case was about a mining company who wanted to discharge its pollutants into a body of water and that was near their mining operations. And the Army Corps of Engineers, the federal agency involved in this case, has a process for determining the permitting process is long, but the agency can give you either a temporary sort of decision or determination or an approved decision as to whether the water that you want to pollute, let's face it, is U.S. water and therefore governed by the Clean Water Act. So in this case, the Corps ruled that in that determination, it did an approved one or a final determination and said it is U.S. waters and mining company are governed by the Clean Water Act. And so going through the first two criteria, the first phase is determining is it a final agency act, and there's two prongs to that. First, what is the evidence that in the regulatory scheme that the decision by the agency is final, and the court looking to the statute that said this kind of determination, the regulation, this kind of determination is final. Those were the words in the regulation governing this administrative process. So based on that and the fact that there were, so the second prong is legal conclusion, the second is that there are legal consequences, to the agency decision. And since in this case, there was finality and the agency's decision had legal consequences, if you got this pass, if you will, the safe harbor, then you could, discharge away and face relatively low risk of legal liability. And if you didn't, then if you did discharge these materials, then you would be subject to, liability. And so the court found there's legal consequences. And then the second phase, the court looked to, okay, so there's finality, but is there, does the mining company have adequate alternatives to pursuing a court decision? And the court said that the company doesn't have any alternatives. It would just have to, pollute and risk, legal liability or go through a very arduous process. And so those are the standards. And the theme is, we're probably going to have to be doing a lot of challenges that have to do with regulatory agencies. And, these are important cases to be mindful of.
Thanks, Mona. I want to remind everyone that we're open to your questions too. If there's a case you have a question about or a topic you want to know if was covered last term, let us know. You can hit us through the YouTube live chat, or you can email me, Amanda Moore, M-O-O-R-E, @povertylaw.org. I want to turn to one of my favorite nuggets, which is standing. Jane, I'll start with you on that one. What did the court say about standing last term?
Well, why don't you start with Gill on that one?
I love putting Gill on the spot today. When you wear a tie, this is what happens to you.
That's actually the whole plan here. There are two standing cases. Gill's discussing one. I'm discussing the other. His is more important. So I think he should go first.
All right. Well, the one Jane describes as more important is called Spokio Inc. versus Robbins. And the issue there revolved around whether there was injury in fact. In that case, incorrect information was posted by a consumer reporting information, and it wasn't clear that it caused the plaintiff any harm, but he brought a lawsuit, a class action, because he claimed that it violated the Fair Credit Reporting Act, regardless of whether it caused him actual harm. And so that was really the issue here. The Ninth Circuit, in a decision by a very conservative judge, concluded that there was standing, and the Supreme Court took the case specifically to decide whether standing was conferred because Congress created a right of action based on the bare violation of a federal statute. In other words, violating the federal statute, regardless of what, violating the federal statute would be deemed to be the injury in fact. And injury in fact, as all of you probably know, is usually a major problem for us in standing issues. That's what they took the case for. That's not what came out of it, probably because when they dealt with that issue, they came up 4-4. So they decided to go a different route, and it ended up with a rather odd majority opinion on behalf of 6 justices by Justice Alito. He recited the traditional language about injury in fact. It said that it must be, quote, concrete and particularized, end quote. And those are words which appear in virtually every injury in fact decision that ever comes out. But for the first time, he said those were 2 different requirements. Particularized means it affects the plaintiff in a personal and individual way. And concreteness means the injury must be de facto, actually exist, real and not abstract, and it can be tangible or intangible. That definition of concreteness is considered by most commentators very vague, very unclear, and providing little guidance to lower courts as to what concreteness is or as to how it differs from particularized. They sent it back to the Ninth Circuit because the Ninth Circuit had not analyzed the concreteness requirement as a separate entity. It just looked at the whole package, and essentially the Supreme Court said all you looked at was particularized. The dissent by Justices Ginsburg and Sotomayor said that there was concreteness here, that the inaccurate information actually did cause Mr. Robbins harm because it might have prevented him from getting a job based on that incorrect information. But what's really interesting is that neither the dissent nor the majority dealt with the issue for which the case was taken. And as I said, that was probably because there was a 4-4 split. The bottom line for us on this case and why it's important is that we now have to deal with concreteness. You can't just say concrete and particularized and sort of mush them all together. You have to make that showing of concreteness in order to demonstrate injury in fact. And since no one yet knows what concreteness really means, it could be a problem. So you definitely want to be taking a look at Spokio if you've got any standing issues.
Thank you, Gill. And Jane, now to the less important standing case.
But the less important, but the one that has the more interesting facts, I think. The case is called Whitman versus Person Hubala. It's at 136 Supreme Court 1732. This is a case that came out of the state of Virginia. Voters there brought an action in court against the State Board of Elections, arguing that a redrawn congressional district resulted in unconstitutional racial gerrymander. 3 congressmen from Virginia intervened in the case, and this is something that we're seeing, particularly those of us who work in the health area and care, where members of Congress will go into court to argue about the way legislation has been drafted or the way that activities by other branches of government have gone down. So these 3 congressmen intervened in the case in support of the redrawn plan. The 3-judge district court panel ruled in favor of the voters and ordered the state to come up with a new plan that did not result in unconstitutional racial gerrymander. The State Board of Elections didn't appeal, but the congressman did. And there is a provision in the U.S. Code that provides for decisions from 3-judge district court panels to go straight to the Supreme Court. So that's what happened here. The case went straight to the Supreme Court. The Supreme Court asked for supplemental briefing on the question of standing. The congressman submitted supplemental briefing, and after reviewing that briefing, the honestly issued a fairly crisp opinion dismissing the case for lack of jurisdiction. Justice Breyer wrote this unanimous decision. He first of all pointed out that when you have a case involving intervention, the intervener just doesn't simply step into the shoes of a party for purposes of appeal. Rather, it has to independently establish its own Article 3 standing. And so we looked into the record to see what the evidence was, particularly for injury in fact. As Gill pointed out, injury in fact is big for us usually, and is also just a critical aspect of Article 3 standing. The other 2 parts of it being injury that's fairly traceable to the alleged conduct, and then a likelihood that the injury will be redressed if you get a court order. Anyway, back to the facts of this case. Justice Breyer looked through the record and found in it an argument that the congressmen were making that they would have their re-election chances spoiled if the district court's order to redraw the panel was allowed to stand. But he didn't really find any evidence of this harm in the record. It was just a bare allegation. So he said, in concluding a rather, as I say, crisp opinion, that when you're invoking federal court jurisdiction, you cannot simply allege a non-obvious harm without more. Here, there is no more. So the bottom line on these standing cases is, in your complaint, or if you're intervening in a case, in your memo and motion, it's important to allege all 3 parts of the Article 3 standing requirement. In particular, pay attention to injury in fact, and where there is a record, support injury in fact in the record.
We have a question from Mark in Toledo, and I want to put this to the group. This it gets back to our sort of opening conversation. Are we being naive to think that the Supreme Court with the 9th Trump appointee will strictly follow these no deference cases if the 5 justices don't like the old rules and like the new rules?
Well, I will just say real quickly that the opinion that Gary bailed Gill out on is a 6-2 opinion. So the new judge wouldn't make wouldn't change the majority here.
You know, it's there's another case that also discusses deference, and you can make an argument, I think, generally that one of the most important cases of the last 50 or 70 years was the Chevron versus Natural Resources Defense Council in 1984, which established the deference rule and therefore empowered the vast bureaucracy of administrative agencies to create laws that were that would be upheld so long as they looked sort of reasonable and so long as they didn't contradict some explicit provision of whatever the statute was that they were issued under. So Chevron is an incredibly powerful case, and deference is an incredibly powerful doctrine for any bureaucracy. But the conservatives on the Supreme Court, to the questioner's point, have been pretty consistent in being very skeptical of Chevron. And of course, Scalia and those guys, when they wanted to reach a result, you can reach any result you want under Chevron by manipulating the test. But Scalia and Thomas in particular, they're skeptical of Chevron in general. They see constitutional problems with Chevron. So in this term, in a case called, what was it called? Cuazzo Speed Technologies versus Lee. It was a patent dispute and of no relevance, I don't think, for most public interest attorneys, and complicated. And I had no understanding of sort of the merits of this dispute over some patent. But part of the issue was whether or not a regulation that the Patent Office issued that had to do with the standard of review that the office applied to resolve this dispute that the guy who lost the case didn't like. Whether that regulation was valid and a valid promulgation of the agency's authority under the patent statute. And the majority, because there was in the statute itself, it said yes, and the Patent Office has authority to issue regulations pursuant to whatever this issue was. The majority had no trouble concluding, well, that's a valid exercise of authority because it's in the statute, right? And then they decided that it was also reasonable under Chevron, and so the challenger lost. Now, that's all sort of a normal deference kind of a case, but Justice Thomas and Scalia also. He filed a concurring opinion. He said, yeah, that's all okay because the statute itself told the agency to promulgate a regulation about this issue. But mostly Chevron occurs where there is not an explicit delegation of authority to issue regulations on the particular issue to the agency. The agency does it to fill in the gaps that the statute leaves. Thomas thinks that he thinks that when Chevron is applied to those kinds of regulations, he thinks that's a fiction. And he thinks that raises separation of powers problems between the legislative branch and the executive branch, and that it's a usurpation by the executive branch of the power delegated to Congress to make statutes. So he said, yeah, that's okay in this case, but in the future, I still am going to complain to you guys, the other members of the court, about this issue of deferring to agency actions where there is not a very express delegation in the statute to the agency to issue rules on whatever the issue is. I think that also can be a useful or could be a useful bulwark for people like us if this new administration starts doing crazy stuff administratively. And I think that of course, again, justices will do what they want to do to reach a result they really want to reach. But Scalia and Thomas have been pretty consistent, and Alito too, over the years about this issue, irrespective of kind of how the result came out.
Thanks, Gary, and thank you, Mark, for that question. We are nearing the end of our time. I want to ask you all one more question about this term that we're in now. Have you found any cases that we need to watch for this term? What are the likely cases that we may be talking about at this time next year? Has anything come up?
They haven't taken as many cases as they normally would have taken by this time. And there have been several cases that they took a long time ago that they haven't even set for argument, presumably because they were waiting for the ninth justice. So I think they're a little slow out of the starting gate this year. And offhand, I can't think of any cases that we'll be focusing on, but there always are some.
All right, thank you to all four of you, and thanks to everyone who has tuned in. Just a second. All right, I do want to remind you all, we just barely touched on anything that's in this article. It's really chock full of useful information and interesting analysis. So I'll remind you to check out their actual article. You can read it. It's the Supreme Court's 2015 term, Access Decisions from an 8-Member Court. And you can find that at povertylaw.org/clearinghouse. I also invite you to join the Shriver Center's mailing list at povertylaw.org/join and follow the Shriver Center on LinkedIn. I want to invite you to join us for next month's Advocacy Exchange. At that time, I'll be joined by members of the Shriver Center's advocacy team, and we'll be talking about what a poverty and racial justice agenda might look like as we're going forward into this new political environment. So that should be a pretty interesting discussion. We'll have that one the Wednesday after the inauguration. It'll be Wednesday, January 25th, same time as today, 1 o'clock Eastern and 10 o'clock Pacific. So I will thank all of you again. There's so many of us, I won't run down through the individual thank yous, but know that I appreciate you being here. Thanks to all of you out there. I do hope we'll see you back in January. Until then, have a wonderful holiday season, and we'll see you in the new year. Thanks.
Thanks, Amanda.
Thank you.